Hello, and welcome to today's session. Learning Outcome LO2. Understand the different types of international sales contracts. In international trade, sales contracts play a crucial role in governing the purchase and sale of goods across borders. These contracts clearly define the rights and responsibilities of both buyers and sellers, covering essential aspects such as delivery, payment, and the transfer of ownership. Given the complexity of international logistics and legal frameworks, well-drafted contracts are vital to prevent disputes and ensure smooth transactions. Today, we will explore the key types of international sales contracts, their main features, and their significance in facilitating secure and efficient global trade. International sales contracts serve to clearly define the obligations of each party. They allocate costs, risks, and responsibilities for transportation, insurance, and customs duties. These contracts set out delivery points, timelines, and transfer of ownership. They provide a legal foundation for resolving disputes. Ensuring both parties know their responsibilities is crucial for smooth transactions. There are several types of international sales contracts, categorized by delivery and payment arrangements. Cost, insurance, and freight contracts require the seller to handle shipping and insurance. Free on-board contracts transfer risk once goods are loaded onto the ship. Free alongside ship contracts end the seller's responsibility once goods are beside the vessel. Ex-works contracts place maximum responsibility on the buyer. The ex-works term places maximum responsibility on the buyer. The seller's only obligation is to make goods available for collection. The buyer handles all costs, risks, and export formalities. This is the least favorable term for the seller. It is often used when the buyer has a strong logistical network. In an FOB contract, the seller must deliver goods on board the vessel nominated by the buyer. The seller bears all costs and risks until the goods cross the ship's rail. Once on board, ownership and risk pass to the buyer. The buyer arranges transport and insurance. This is commonly used for bulk shipments. Under a CIF contract, the seller handles supplying goods, arranging shipment, and obtaining insurance. Risk transfers to the buyer once goods are loaded on the ship. The seller pays for transport and insurance. This is a common contract in international trade. Buyers benefit from included insurance coverage. In an FAS contract, the seller's responsibility ends once goods are placed alongside the ship. From that point, the buyer assumes all costs and risks. This type is used for goods shipped in bulk or by sea. It is suitable for commodities like coal or grains. The buyer handles loading, shipping, and insurance. Under a DDP contract, the seller bears all risks, costs, and duties until goods reach the buyer's premises. This includes export and import customs duties, insurance, and transportation. DDP offers maximum protection to the buyer. The seller manages everything until delivery. It is suitable for exporters with strong logistics. In a CFR contract, the seller pays for the cost and freight to the destination port. Risk transfers to the buyer once goods are loaded on the vessel. Unlike CIF, the seller is not responsible for insurance. The buyer arranges their own insurance. This contract is suitable when the seller wants to manage shipping. Under FCA, the seller delivers goods to a carrier nominated by the buyer. The seller handles export customs clearance. The buyer assumes responsibility once goods are handed to the carrier. This type is suitable for all modes of transport. It is commonly used in containerized shipments. CPT and CIP terms apply mainly to multimodal transport. Under CPT, The seller pays for carriage to a named destination. Risk transfers to the buyer once goods are handed to the first carrier. Under CIP, the seller also provides insurance. These terms are common for air and road freight. The CISD provides uniform rules for international sales between businesses in member countries. It covers formation, obligations, remedies, and risk transfer. The convention excludes consumer transactions. It encourages trade by establishing predictable and fair rules. The CISD reduces conflicts between different national laws. Incoterms define standard trade terms used worldwide. They clarify when risk and cost pass between buyer and seller. These terms reduce disputes by standardizing interpretation across jurisdictions. Incoterms help in minimizing ambiguity in contract interpretation. They are essential for efficient logistics and risk management. UCP 600 regulates international trade finance. It particularly governs letters of credit used for payment under international contracts. The UCP ensures uniformity in documentary credit practices. It provides a framework for handling payment disputes. This regulation is crucial for international transactions. When drafting international sales contracts, parties should clearly define price and currency of payment. Delivery terms using correct Incoterms are crucial. Transfer of risk and ownership must be specified. Insurance responsibilities and inspection rights should be outlined. Governing law and jurisdiction clauses are essential. In international contracts, property refers to legal ownership and risk refers to who bears loss if goods are damaged. These do not always transfer at the same time. Incoterms provide standard points of transfer based on delivery. Understanding these transfers is crucial for managing liability. Insurance and payment obligations are affected. Traditionally, risk follows ownership unless parties agree otherwise. However, Incoterms often modify this rule. In CIF and FAOB contracts, risk passes at shipment, while property passes later. In AXO contracts, risk and ownership pass simultaneously. Understanding these principles helps in managing trade obligations. In CIF contracts, delivery is based on documents rather than physical goods. The buyer has the right to reject non-conforming documents. Rejection rights also apply if goods do not match the contract upon arrival. Prompt rejection is necessary to retain rights. This ensures sellers remain accountable. Conflicting national laws create uncertainty in international contracts. Different interpretations of terms like delivery or risk increase legal costs. Harmonized systems like CISD and Incoterms provide consistency. They ensure contracts are interpreted uniformly across borders. Harmonization is essential for global trade efficiency. These contracts are fundamental to international trade law. They define when risk and ownership transfer. They determine who pays for transport and insurance. Obligations under the Sale of Goods Act and Incoterms are clarified. They ensure clarity and prevent disputes between international parties. Common forms of international sale contracts define how costs, risk, and responsibilities are shared. Choosing the right contract depends on control over shipping and logistics reliability. Standardized Incoterms ensure transparency. They reduce disputes and allow for smoother transactions. These contracts are essential for global trade. In conclusion, mastering these principles is essential for ensuring the success of global transactions. If you have any questions, please don't hesitate to get in touch via text or phone at 07000 484,361,688. I appreciate your attention and look forward to seeing you at the next session.